Unfortunately, before the status check hearing, Mr. Prince and Miss Houston were murdered, as we all know, as well as Mr. Joe Houston, who was also killed at the time, or killed himself, excuse me. Is that everybody? All right. Houston versus Houston, case number D, 24-688-260-D. Parties, please state their appearances for the record. Let's start with the actual parties. We have anybody here for the plaintiff or the defendant, and then we'll go with the interveners, and then we'll go with Ms. Fine. Anybody representing any of the parties here? Mr. Evans, aren't you representing the special administrator?
Right. I questioned whether you thought we were representing interveners because we did intervene in the proceeding. But yes, Ross Evans, bar number 11374, on behalf of the estate of Ashley Prince, the administrators of the estate who have intervened in this case, Your Honor.
Oh, so you're actually an intervener as well. Okay. Ms. Fine, why don't you make an appearance, if you would, please, for Ms. Manchin? Ms. Fine?
Oh, okay, thank you. I was muted. Fran Fine, bar number 25, present and on behalf of the real party in interest, Elena Machine.
Ms. Fine, are you going to be making a video appearance? Or are you having a problem with your video?
No,
or?
I'm absolutely not having a problem with it. I don't know why it's not doing.
Looks like it's off. Let me see if I can do it on my end to get you to ask to start your video. There we go.
Nothing is nothing is coming up on this. And I've done it a million times.
In the meantime, we have somebody here from the media. I'm going to need you to make an appearance. Dory, what's your last name for the record? Ms. Rachi. All right. Thank you. Anybody else? We have my extern that's on as well. Otherwise, this is a sealed case. Are we missing any of the interested parties to this motion?
Not that I know of, Your Honor.
I don't believe so.
All right. So, Ms. Fine, I want to make sure I know where we're at here. And let me give a summary of where I think we're at here, and then you correct me if I'm wrong, okay? How's that?
Okay, you got it.
So to back up here, and I apologize for having to push this out to this week. I was unavailable last week. I had a surgery in my throat, and I thought I was going to be able to have calendar, but I wasn't able to. And then Commissioner Truman conflicted out of this case, so that's why it had to be for me. So I do apologize for moving you guys around. I don't like to do that, but there was really no way around it, to be honest with you. So in any which case, my understanding, and again, I'm going to give you kind of a summary of where I'm at, most of which is already well versed through the pleadings in this matter. But as a part of discovery, there was a subpoena served on Elena Machine. I hope I'm pronouncing her name correctly. And it had to do with some of her text messages and communications that she had. It's Elena, sorry. I'm sorry, not Elena, okay. Elena. It had to do with some of her text messages and some communications she's had with some of the parties in the matter. There was a motion for protective order that was filed or to quash the subpoena. And that was filed sometime in January. A hearing on the motion was conducted in front of me, and I believe it was March 12th. And I recommended that the motion be granted in part and denied in part. The reason why I felt that the subpoena was appropriate to issue was because Ms. Machine was listed as a witness. There was representations made from Mr. Joe Houston at the time that she had some very damning information as to Mr. Prince and Miss Houston. And therefore, I believe that the information sought was relevant and proportional. I did, however, believe that the subpoena was overbroad and sought way more information than I felt comfortable with or thought was proportional to the needs of the case at the time. So that was kind of a general overview of what was happening. I set a status check because I wanted Ms. Manchin's attorney at the time to gather the requested documents and do a proper privilege log and submit it for an in-camera inspection for me. And I set a status check for April 16th on that particular issue. I wanted to find out what actual information was going to be obtained through that subpoena and whether or not it was, one or two texts or whether or not we're talking about a series of information that showed a relationship between the parties, and certainly something that I felt may go towards bias to this person's testimony at the time of trial, as it was proffered that she was going to be offering. Unfortunately, before the status check hearing, Mr. Prince and Miss Houston were murdered, as we all know, as well as Mr. Joe Houston, who was also killed at the time, or killed himself, excuse me. My understanding was that the status check and everything was taken away from me at the time because there was a series of emergency motions that were filed in the case. And Judge Henderson basically vacated everything and wanted one combined hearing, which he had on April 17th. At that particular time, after hours of hearing on the emergency orders, Judge Henderson actually ordered the issue back to me with regards to the attorney fees issue. Now, at that particular time, the discovery was moot. It didn't really make any difference at that particular time, right? I mean, there wasn't anything that was going to be going forward on the particular issues that were being brought through the subpoena.
I don't believe that's true, Your Honor.
Well, I can tell you that
because the case was set for an evidentiary hearing in which my clients were the representative parties, and we've relied in large part on the discovery conducted to date.
Well,
it ended up settling.
Mr. Evans, the issue had to do with Dennis Prince being around these children and his ex-wife's testimony with regards to that and her bias. So I doubt very seriously that was the main issue that was going to be determined at that particular time.
I understand, Your Honor, and
since he wasn't around. So
I understand
the discovery issue was relatively moot as to Ms. Manchin and the subpoena and the issues that were going to be in front of me. That's how I understood it.
I apologize, and I appreciate your clarification, Your Honor. All
right. So what happened was I got a directive to award what I felt like was a directive to award attorney fees. It appeared as though the judge, under the circumstances, felt that at least from the way it was directed towards me on the original order, that attorney fees needed to be awarded. So what I did was I encouraged Ms. Manchin to file a memorandum of attorney fees and cost pursuant to Brunzell versus Golden Gate. And I wanted to evaluate the attorney fees issue, and I started dealing with that. Now, again, there's two issues with attorney fees, right? One is whether or not they're going to be granted, and the second is the reasonable value of what those services are for the work that I believe to be appropriate for doing it. And under NRCP 45, I had the authority, as well as NRCP 37 to 37A5A to award attorney fees. There was a request for an obscene amount of attorney fees in the amount of $28,000 that was requested. I reviewed that and felt that that a appropriate value of attorney fees would have been around $10,000. Fees and costs, excuse me, would have been about $10,000. And at that particular time, I did come to the conclusion, however, though, that the information sought was reasonable and proportional, and the yielded discovery information that I believe to be likely to be discoverable as well as admissible with regards to bias. Again, because Ms. Manchin was listed as a witness who supposedly was going to be offering some testimony. On August 19th, so I filed a report and recommendation on that. On August 19th, it's my understanding that there was an objection to the report with regards to the fees as they were awarded against, at that time, the only party that had, the party that had actually filed the original motion, excuse me, the party that actually issued the subpoena and prompted the discovery dispute, that would have been Miss Ashley Houston. So at that particular time, Judge Thorne then heard the objection, and when I issued it against a party who was deceased and not substituted in, it is certainly undisputed that obviously she had died before the fee award was issued against her. And therefore, Judge Thorne correctly found that once Ashley died, the court could not go forward with consideration of the request for attorney fees against her without the substitution of a personal representative at all. So therefore, she reversed the order with regards to the fee award against the defendant. And so as I see it, Ms. Fine, this is where I get to you. As I see it, as I sit right here, we basically start over and we revisit the issue of whether or not, now we have some more clarity about what's going on, whether or not attorney fees are appropriate versus the special administration. And then secondarily, if so, the amount of the fees and what's reasonable. Am I wrong in that?
Well, I believe, Your Honor, that the only problem we had is we didn't have a personal representative, and I corrected that. And I corrected that we thought we had a personal representative when the Pages intervened to be special administrators of the estate. But as Judge Throne said, they filed to be special administrators for custody only. So that was the confusion, and I apologize. So she did give me permission to file a motion to appoint to substitute parties. I did. I substituted Ashley for her parents. And once we did that, the judge granted that because nobody objected. And so then I filed a motion for a ruling on the merits. The merits had already been argued before you, Your Honor. You had already made a decision. And so Judge Throne did not make a decision with respect to the merits because you had. And so therefore, now that we have personal representative in place, and now that we know that there's going to be money coming in eventually from insurance companies and wherever else, that money can be paid. Now, I know it's not going to be paid immediately, but we do need a judgment. And in reality, it was a reasonable decision that you made. And it was made on the merits of the subpoena being overbroad. And it did cost her far more than the $28,000 because she had expensive counsel. So you were reasonable in your granting of the $10,000. And now, unfortunately, she's had to spend even more with me. And I'm trying because I know her.
Well, here's my problem. Couple of things. Number one is my first question was, are we not starting all over again?
No.
Are we not now looking, so you're asking me, because if I'm looking at Judge Thorne's order, specifically says that the discovery commissioner's report and recommendation that a judgment be entered against Ashley and in favor of Elena for attorney fees and costs are reversed. So therefore it's gone. I don't have any authority to be able to overrule the judge.
It was reversed until we filed a motion, because if you look at the next motion that I filed, because I filed a motion for reconsideration, she said, I'm not going to grant the motion for reconsideration, but I also asked for related relief, but I will grant your motion for related relief. And the related relief was to file the motion to substitute party. And we did that.
And then to refile the motion with me on the issue of attorney fees, correct?
I'm sorry?
And then to refile the motion with me, basically starting over and asking me to evaluate the attorney fees issue, starting from the beginning. Am I wrong?
Well, I believe that would really be redundant and hard for you and difficult for you to do, and a burden.
Why would she send it back to me then?
She sent it back.
Why wouldn't she just deal with the issue?
Because you're the one that's familiar with it. It was briefed before you, Your Honor, and you're the one that knows the most. So,
but if she was going to accept my review of it and thought that was a reasonable award, she didn't need me to relook at it again. She could have just awarded it against the party that you wanted it to. I mean, it just seems procedurally that you're. That's the first question I have. Okay, that's the first concern I have about where we're at. The second concern I have is, what's the purpose of attorney fees on these situations? There's a couple different reasons, right? As you well know, I'm sure, is to punish the person for. Well, I say punish. That's probably a bad. What's that?
I don't want to use the word punish. I said that to her.
Right. It's probably a little aggressive, but the reality is that to have some detriment to somebody who files something that causes some litigation that didn't need to be filed, and therefore hopefully they don't do it again, right? I mean, that's the whole point of doing a motion for sanctions and for fees when you do that under NRCP 37A5A as well as NRCP 45. So I'm finding a little bit of a void there because, again, I go back to the original order from Judge Henderson. Judge Henderson essentially set this to me to order fees, and I thought I was just looking at the reasonable amount, and I think that might have been a mistake, and that's where I'm a little bit concerned.
Okay.
Because I got to be honest with you, I'm looking at this. it doesn't feel as though the purpose of the fees for what we do here in discovery is there anymore.
My client is, so in other words, the personal representatives did not oppose the stated purpose of Elena's motion. The matter having been fully briefed by you, the court should enter. So we determined that it was our opinion, by virtue of what the court had said, that you would just entertain oral argument and decide the issue on its merits as you already had. But if you believe that we need to start all over again, I just think that's a waste of your time, but I'll do whatever you think is important. But what is do you have an opinion now of what the attorney's fees should be? I mean, Elena is an innocent party here. She didn't cause this.
Well, no, that's not true, Ms. Fine. Ms. Fine, that's absolutely not true.
Okay.
She is a third party, but she was still listed as a witness. There were still emails back and forth that indicated that she was communicating with some individuals. There was information within that production of documents that showed that she did have some bias towards Mr. Prince and or Ashley. And it did show that there was some information that was going to be, I didn't make that ruling, but I had reviewed the documents, that there was going to be some information that was going to be discoverable. It wasn't as if the subpoena was completely 100% frivolous and wasn't going to give any information whatsoever that was going to be what I thought would be admissible towards her bias. She injected herself into the matter, in my opinion, at the time, and I said that on the record back then, that she was a witness, and he had the right to be able to do some discovery on that. Now, it was very ancestral, and there was a lot of other stuff going on that made it obviously very, very personal and very emotional. But the reality is that as any other witness, she was saying some things in some of these communications that were going to be and could have been used against her in her bias towards some of these individuals. And I felt that was relevant proportional. Yeah. Mr. Prince had asked for every one of her computers, every one of her phones, every device that she had be imaged so that he can pick through it and figure out what he wanted. Obviously, that was completely the opposite, was way overbroad.
Right.
And by the way, we deal with stuff like that on a daily basis here in Discovery. I mean, literally, I have 2 other cases today that we were doing that. I mean, we do that. Now, some of this is a legitimate dispute, and some of it is a little over the top. I will be perfectly honest with you. I believe this went wrong when the judge sent this back. First of all, the judge took it away from me. When he took it away from me, I was confused as to whether or not what my authority was. I tried to give him a call and communicate with him before I had actually even delved into this. And I was told that he just wanted me to look at the attorney fees award for having to file that motion. So I was a little bit confused at it. I went back recently and looked at the hearing on this particular issue as to what that discussion was. And he really basically said, oh, I don't know what's going on with that. Just go ahead and have the discovery commissioner. That wasn't my understanding originally. My understanding originally was this person needs to be compensated for having to be involved in this case, and you need to take a look at it. And I think I made a mistake on that, Ms. Fine. That's where I'm at.
So would you like to set it for a hearing so that we can argue it, or are you prepared to make a decision today?
Well, I want you to be comfortable in fully briefing it if you feel that, because I know in your reply, you said you hadn't felt as if that you needed to argue the merits of it. So I don't want to take that away from you if you still believe that you need to do that, because you still have some due process, obviously, to be able to object to that and with Judge Throne. So I'll give you the.
Oh, I'm sorry. I just wanted to say that a personal first of all, when we filed the memorandum of fees and costs pursuant to Judge Anderson's ruling, nobody ever objected to that. And when Mr. Jones filed his objection, I believe it was fictitious. I don't think he had standing to do it. He wasn't representing anyone. He certainly wasn't representing the estate. So
that's above my pay grade. I'm sure you made that argument to Judge Throne, but that's way above my pay grade, as you know.
It's just, I just think this is a big, it was overbroad. I don't know if you're aware, and I don't know if I should bring this up, but in her divorce decree from Mr. Prince, he had a clause in there that she would be held liable for any disparagement. And so that's why he wanted all of her computers. But the point is that you made a reasonable decision. And if you want us to brief it, I'm happy to brief it. But right now, the fees that she's had to spend for this, it's just not fair. But if you have to make your own decision and your own ruling. If you would like us to re-argue it, I'm happy to do it. But if I think that you've already made
Are you prepared to do that today, or do you believe that you need to brief it more?
I honestly think I need to brief it more because yeah.
I don't want to wait. I don't want you. I mean, I'm just telling you where I'm leaning because I do believe that there was some discoverable information there. I did review it.
And you found in this matter that Elena's counsel was charged with defending against an overbroad subpoena ducis tecum, redacted and analyzed responsive documents and prepared for and attended subsequent hearings. And under the circumstances of this case, that's what you said. You said it then?
Okay, no, Ms. Fine.
Yeah.
I need to correct you on that.
Okay.
And let me tell you, on page 4 of your brief, you put the discovery commissioner found. And I want to tell you that in discovery, we have forms online. Okay. And if you look at the report and recommendation, you will see starting on page 6, which is about a page and a half before your quotation, it said, plaintiff argues each of the Brunzell factors as follows. So if you look at my DCRR, dated August 5th of 2024.
And page 6?
If you look at page 6.
What line? Sorry.
Line 22.
Okay, I'm there. Plaintiff argues.
It says plaintiff argues, and I actually underlined that under our forms because these are your arguments.
Okay.
And you quote this as my findings when it's really your argument, because your argument that you pulled that from is about 2 pages later. Okay. It's still under that section that you argued. So those aren't my findings. I just want you to realize that. I mean, it's not a huge deal, but you pointed it out again. I wasn't even going to mention it, but you pointed it out again just now. And I have to tell you that those are what you argued. I did take that into consideration, which I do when I'm determining whether or not fees are appropriate to award. But I didn't make that finding. That wasn't my finding. That was something that was argued, which is okay.
I'm sorry.
I would say that I did make the finding that the subpoena was appropriate to issue, but it was not appropriate in the breadth that it was asking for and needed to be severely limited. And I did do that. Right. And then once the documents were received, I did receive, I think it was 40, might have been 80 pages. And I thought about 30 or 20 pages or something of that nature was appropriate to be disclosed. Some of which I didn't think was appropriate to be disclosed, even though it still fit within that limitation that I had. So, but I never came to that ruling. I never even got there because of what happened, obviously. So with all that said, Ms. Fine, I don't want to take away your opportunity to be able to fully brief this so that you do have your proper due process in case you feel like you need to take this up. I don't know that I would ever revisit the amount.
I'm not asking you to.
I think because I fully looked at that. But I'm telling you, when I took this from Judge Henderson, my understanding was, my directive is to look at the reasonable amount of fees and award fees. It wasn't to look to see whether or not fees were appropriate.
Okay.
And I think that's where this thing went the wrong direction.
I see. I wasn't asking for that either. I was asking for what you felt was appropriate.
Yeah, I think that amount, assuming that I would award fees, would be appropriate, but I'm a little concerned that looking at in total of the purpose of this, whether or not the special administration should be sanctioned for a subpoena by 2 people that are no longer around anymore in litigation that's no longer around anymore. I find it difficult that a sanction should be issued against that particular the special administration at this point. But
they're not being sanctioned, Your Honor, with all due respect. They're not being sanctioned at all. It's sad, and I'm sorry that it happened. Nobody wanted this to happen, but it happened. And so now is this my client supposed to be left out in the cold? I mean, they say that she has plenty of money. Well,
that's not my consideration. I don't take that in consideration at all, but whether or not she's got money or not, that has nothing to do with this.
So they're not going to, I believe there's insurance money coming, and that insurance money is going to be responsible for paying a limited amount, but I'm sure it's going to be.
Well, that's also not an issue for me. How it's going to be done that way. My point, Ms. Fine, is that under NRCP 37A5A, it says if there's a motion that is granted, which this motion wasn't even granted. It was granted in part and denied in part, and I had some limitations on it. That's first off. Second of all, there's 3 exceptions to that, and the second exception is whether or not the opposing party's non-disclosure response or objection, or in this particular case, issuing the subpoena, was substantially justified. And I felt like there was a legitimate good faith dispute between the parties as to the extent of whether or not this subpoena should ever issued. Now, when I first read the motion, I could tell you, I'm going, Mr. Prince is subpoenaing his ex-wife's computers and all this other stuff. But when you delve into it, there was a basis for it, which makes it a legitimate, good faith discussion. So again, that's what I want to focus on, the reason for the sanctions and whether or not those still exist or not. That's really what I was hoping to focus on.
Well,
And if you want an opportunity to be able to be briefed on that issue, I don't want to take that away from you, because I know that you spent a lot of time and energy on this.
I've spent
already.
a lot of time and energy on it, because not only did my client lose her ex-husband that she was in love with as well, but before she left her for Miss Houston, that wasn't the reason she did this or filed this. She only wanted what she just felt it was inappropriate for her to even have been brought in. So I think it was totally inappropriate for her to have been involved with this, but then again, you found other reasons.
To be perfectly frank, she was involved in this before Mr. Prince subpoenaed her. She was involved in this when Mr. Houston, Joe Houston, listed her as a witness and wrote what she was going to testify was that she was going to be disparaging Mr. Prince and Miss Houston.
And interestingly enough,
so that's why she got brought into this. It wasn't because of Mr. Prince.
And interestingly enough, if any comment was made by Mr. Houston, who can't defend himself either, it was hearsay. Because how did he
I agree with you. That's why Mr. Prince was entitled to be able to determine bias. If that was going to be the case, he could have taken her deposition too.
Could have.
Which was coming down the pike.
Right. It was the next week.
Yeah. So in any which case, that's where I'm at, Ms. Fine. I want you the opportunity to be able to brief it if you'd like to. How long do you need?
Can I have a week to think about it and talk to my client and
well, I'll tell you what. You tell me how long, assuming that you are going to brief it, how long you need. I'll set a hearing on that. If you decide not to do that, just put us on notice that you're withdrawing it and we'll go from there.
Okay. So can I, let's see, this is the 12th. Can I get 30 days or do you want me to brief it in 30 days or do you want me to tell you in 30 days?
You tell me the time frame you want. Obviously, there's no hurry and no timing on this case anymore. So
30 days for me to be able to read it and review it, because I wasn't involved in the beginning. And then if I'll either in 30 days, if you want to set it, I'll let you know whether or not I want to go forward or not, take it off calendar. And if we want to go forward, I'll tell you then, and then you can give me another 30 days if you want.
All right. I'll set it out for 3 months. How's that?
Okay.
All right. And that'll give plenty of time for any opposition, any reply that you want. If you'd let me know within 30 days whether or not you want to have that hearing, that would be great.
Fine. That's fine. We'll do that. So 30 days. So today's March 11th. I can't believe it was March 12th that you had the last hearing on this. Very sad situation. I can't believe how quickly the year went by.
Yes. So 30 days today from today's date, you'll file a supplemental brief one way or the other, saying either that it's going to be vacated or that it's just do a stipulation in order if you're going to vacate it. But otherwise, your opening brief regarding the attorney fees against the remaining parties to the case, or intervener or whoever you're seeking it from, I guess is the more specific issue, because that's going to be the legal issue that's going to have to be looked at, Ms. Fine, is whether or not sanctions are appropriate against that person.
I hate to use the word sanctions either, but I wanted to say one more thing. Judge Throne specifically said, I'm not making a decision with respect to the merits of this case. That is before Commissioner Ganz, and he should be the one that makes this decision.
I understand.
So I'm just sending it back to him for review, is what I thought.
I understand, but my only authority is sanctions. So understand the rule actually says failure to make disclosures or cooperate discovery / sanctions. So this is a sanction, and that's the question of whether or not it's appropriate to sanction this individual for what happened back a year ago, as we just talked about. That's my question.
I know I'm arguing it, but you're not sanctioning the party. You're sanctioning. They're the personal representatives. You're still making the representative that it was the representation that it was wrong for it to be done, and that it would be as if to say, "Oh, they committed a crime, but they're not around anymore, so we can't blame them." And I guess that's what it's bad enough.
Well, no, what you're saying is, what you're actually saying is that they committed a crime, but we want to put the dead body in jail still, because the penalty still needs to hold true for that person. That's what you're saying. That's how. So that's why I want you to brief. I don't know the answer to that. I got to be honest with you.
Okay.
And, so when you're looking at sanctions, whether or not it's appropriate for a party who's no longer around, based upon an action from somebody else in the past, but this is a sanction. It can't be sugarcoated. That's my only authority.
I understand. Thank you, Your Honor. 30 days, I'll get something to you.
So 30 days, and then we're going to set the actual hearing for 90 days ish.
Okay.
So it's 3 months out.
days is April 8th.
30 days is April 8th for your opening brief and or stipulation, Ms. Fine.
And then
Okay.
3 months is June 10th.
3 months is going to be June 10th. We'll do
Okay.
that at 1 o'clock.
Great.
Actually, make it 1:30.
Okay.
Make it
Thank you.
1:30. And then Mr. Evans, if you're going to be opposing her motion after 30 days, you got the normal time unless you guys stipulate otherwise the briefing schedule, okay?
Thank you, Your Honor.
All right. And Ms. Fine, I want to make sure you understand exactly what I'm looking for. I'm looking for some authority to say that this would be an appropriate sanction for a subsequent, I don't want to even call it party because it's an intervener now. So,
Okay. Thank you.
all right.
Yep.
Thank you. Mr. Evans, did you have anything to say?
No, and I appreciate the court's clarifications, and I do apologize for trampling on your summarization of the record. I misunderstood what you were saying. I appreciate
It's
it.
not a problem. I forgot about it already. So, all right.
All right, thank you.
Thank you, folks. We'll see you in a couple months, maybe.